All right, good morning, everyone. I'm Judge Corey Amanda Cawthon, and this is First Appearance Court. Today, I will let you know if I have determined probable cause, and we will talk about release conditions. Remember that today is not your trial date, and so I encourage you to speak with your attorneys before speaking on the record this morning, because everything that we say is being recorded and can be used against you at a later date. For those of you represented by the Public Defender's Office, know that attorneys from the Public Defender's Office are present both here in the courtroom with me and at the main jail. For those of you at other facilities, know that these attorneys are available to you by phone. For those of you represented by private counsel, know that your attorneys come here to the courtroom and are able to address your cases from here. If your attorney is not in the room when I call your name, you can let me know that, and we will see how we can help facilitate that process. However, I ask you not to tell me that you have private counsel unless you or your family have retained counsel for this specific arrest. You also need to know that in the courtroom with me, I have present attorneys from the State Attorney's Office, as well as representatives from Confinement Status, Pretrial Supervision, and the Clerk of Courts. All of these persons are here to help facilitate this morning's session and to provide any additional information that may be needed. Some of you may be able to resolve your cases here at first appearances if you are here on misdemeanors or municipal ordinance matters, but understand that is dependent on what is going on with you personally and with your case. For those of you here on felony matters or violations of probation where the judge has already set a no bond hold, know that those cannot be changed or resolved here at first appearances. After today, your case will be assigned to a specific division judge, and going forward, all pretrial motions and any subsequent trial will be heard by your division judge. Before I get started with our list this morning, I understand we have a few cases to be taken out of turn. Mr. Miller, who do you have on your list?
Judge, I have Calvin Williams, and he's on page 9 of the court's docket.
Okay.
I have a probable cause argument, but I don't know if we're going to try and resolve this or not.
Is he the only one that you have to be taken out of turn?
No, the next one is Mr. An Alien, who is on page 15 and 23.
15 and 23. Okay, anyone else?
That's all, Judge.
Okay, all right, and Mr. Linder has also requested that one case be taken out of turn if we have him, and that will be Robert Mendez.
And what page is Mr. Robert Mendez on, Judge?
He's on page 19. He also has family present in the courtroom. All right, so I'll address Mr. Mendez's case first, then I'll go to the other two cases that were requested to be taken out of turn, and then I will go to our sign-ins after that. All right.
So the court wants to address Mr. Mendez first, correct?
Yes, we'll do Robert Mendez first.
Okay, I have a seat. Mr. Mendez, or he's not even here yet, Judge?
He's not here, okay.
And Judge,
And does he have private attorney?
He has family present in the courtroom, so when
And I'm
he's,
gonna need a moment to speak to him when he comes.
that's fine. Just
may
let
I-
me know.
I actually, Judge, I'm sorry. This is his wife,
Yes.
Mr. Mendez's wife. She advised me that he does have private counsel. I have reached out to that private counsel and not received any reply yet.
Okay, well, let me just ask, ma'am, has that attorney already been retained for this arrest?
No, because it was late last night and I couldn't
Okay.
get a hold of him.
Okay, so if he hasn't been retained yet, then he doesn't technically have private counsel yet,
I
okay?
heard you, yeah.
All right, so Mr. Romero, let me know when Mr. Mendez is ready, and in the meantime, I will go to Calvin Williams on page 9.
Mr. Williams.
All right, good morning, Mr. Williams. Mr. Williams, you're before the court this morning on one charge of disorderly conduct. I find probable cause. Oh, I'm sorry,
Actually,
Mr.
I
Miller,
had
did
an
you say that you had an argument on this case?
So I read the probable cause affidavit. Apparently there was a report of somebody disturbing people, and
Yes.
then law enforcement spoke to him, told him to move along, and as he was leaving, he began to talk to himself in a loud manner, cursing and yelling. I don't know if talking to yourself in a loud manner can constitute breach of the peace if he's not directing it towards anyone or particularly. It sounds like there's a First Amendment argument here, and I'm not, just wondering if there's really probable cause to hold him for disturbing the peace.
Mr. Linder, you want to make a response?
Your Honor, the allegations at this point in the probable cause affidavit satisfy the elements. Certainly, the defense is free to raise an affirmative defense, but I don't know that that defeats probable cause at a first appearance hearing.
Regard to the First Amendment issue, it doesn't appear that the allegations here are about the content of the speech, but rather the manner in which they were made. So the allegations are that they're being made in a loud manner, cursing and yelling, disturbing the peace. So I think that I do have enough to make a probable cause finding for this morning. So I'll stand by that ruling, and I will hear the parties' recommendations for bond and release conditions. Okay.
Judge, we're going to be asking for the court to consider releasing Mr. Williams' ROR. He advised me he doesn't have anyone to call to help post his bond. And from what my colleague just argued as far as mitigation, I don't even know if this is going to be picked up by the state. So we're asking for Mr. Williams to be released ROR on this misdemeanor offense, Judge.
Okay.
Just checking to see if there's any history.
Okay.
Your Honor, I'm showing Mr. Williams is currently on probation before Judge Allspector for a domestic violence battery. It was a strangulation case that he pled out to misdemeanor battery. He also was taken into custody last October for violating pretrial release. And the basis for that was he failed to call in as he was court ordered.
If he's on probation now, is there a reason the violation of probation hasn't come up?
My only guess, either the arresting officer didn't see that he was on supervision or saw it and made a determination that he would leave it up to his probation officer. Yeah, it's right here.
All right, for today's purposes, I will leave the $25 bond in place. All right, thank you. Okay. Next will be Wilkins and Alien. He's showing twice on our docket. That's because he was on yesterday's docket, and for whatever reason, I have 2 packets for him.
Oh, yeah, I saw that. He's on 2 pages of the document, 15
Yeah,
and 20.
he was reset from yesterday, and there's an ad charge, so. All right. Good morning, Mr. Analian.
Yeah, good morning.
You're before the court this morning on 2 charges. Count 1 is for burglary of an unoccupied conveyance unarmed. Count 2 is second-degree petty theft, third or subsequent offense. I find probable cause, and I'll hear from the parties.
907 380. Yeah. Your Honor,
Hey, Grant,
the
this is
state
Dale
would be
Miller, Broward
seeking
Bond Court.
a,
Calling
Miller,
on
your
behalf
mic is
of
on.
Robert Mendez, picked up yesterday on
Mr.
an
Miller?
old burglary charge. Are you coming
Your
in on
mic
this?
is on. Thank you. Go ahead.
the state would be seeking a $15,000 bond and a GPS monitor level 1, Your Honor. Mr. Analian has 4 pending, can you scroll up, you go down, 4 pending cases in Broward County right now. He's got a grand theft and possession of utilone, another grand theft, and a grand theft auto. I'm sorry, 5 pending cases. Also a burglary of a conveyance with a grand theft. He also has a pending petty theft.
Is he out on bond in all those cases?
I'd have to check. The grand theft and possession of utilone, he was ROR'd. The grand theft, the petty theft, he's out on bond. The burglary, conveyance, and grand theft, he's out on bond. I'm not certain about the other, I'd have to go through each individual
Okay, that's
case.
all right. All right, Mr. Romero?
Judge, certainly, Mr. Naline, I understand the reason why the state's requesting a $15,000 bond, but in speaking when he's not going to be able to afford that. He was going to start working this week at a labor pool. As the court is aware, it's anywhere from $60 to $80 a day that he's going to be making. So he's not financially going to be able to afford to post a bond. Now he's 20 years old, been here his whole entire life. He lives with his parents. He did tell me that he is going to be coming back to court, but unfortunately, he's not going to be able to post a very high bond. Considering the totality, I'm going to be requesting a $2,000 bond on count one on the third-degree felony, Judge.
All right, well, I understand the circumstances, but rather than me revoke his bond and the other pending cases, I'm going to grant the state's request and set bond on count one at $15,000. I'll leave the standard bond in place on count two. If Mr. Alien does post the monetary bond, he'll be placed on pretrial supervision with a level 2 GPS monitor. There's also going to be a no return order. The petty theft charge in this case relates to a 7-Eleven at 8100 West McNabb Road in North Lauderdale. And the burglary charge relates to a location at 6311 Northeast 18th Avenue in Fort Lauderdale. So, Mr. Nalian, the no return order will apply to both of those locations. Do you understand that?
So yes, Judge, I understand.
Thank you. I just took this one off. I think that's from yesterday. I just put the other stuff together so that we have everything. Okay. While we're waiting on Mr. Mendez, I do have another sign-in. That is on Chania Smith, who's on page 1.
Judge, I just been advised by the deputy they went to try and get Mr. Mendez. He went to medical,
Okay. All right.
but
So
he is going to be coming back.
this morning?
Yes.
Okay. Well, I'll just leave him there. So just let me know. If not, we'll deal with it at the end of the docket.
No problem, Judge.
Thank you. All right. So do you have Chania Smith? She's on page 1.
Yes. Yes, Judge.
Thank you.
Ms. Smith, come on up.
She has family in
She's
the
approaching,
courtroom.
Judge.
Thank you. All right. Good morning, Ms. Smith.
Good morning.
Ms. Smith, you're before the court this morning on one charge of aggravated battery. I find probable cause. To the family members who are present in the courtroom, are you here to observe this morning or to speak?
To speak.
Okay, are all three of you speaking or just one? I'm sorry?
All three.
All three of you will be speaking. Okay, a couple of things I want to say to you. Number one, this is just the first appearance hearing, so I am only addressing bond and release conditions this morning. I'm not addressing any of the facts or background of the case. You understand that? Okay, additionally, I tell everyone who comes to first appearances and wants to speak, everything that we say is being recorded and can be used against you or potentially her at a later date. That's important because I don't know if you are witnesses or alleged victims, whether you have spoken to law enforcement or made any statements to them, but you're here without an attorney today, so I want you to understand that, okay? All right, the last thing I'm going to say is if you want to speak, we'll go one at a time. I will swear you in so that you'll be under oath, and then I will hear from each of you, okay? But only one at a time, all right? So who's going to go first? All right, so ma'am, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
All right, and you can put your hand down now, and will you please state your name and spell your last name?
My name is Jeanette A. Morgan, Morgan.
Thank you, Ms. Morgan. And I'm just going to ask you to speak up a little bit and speak into the mic so that they're able to hear you over at the jail, okay?
Okay.
All right, go ahead, Ms. Morgan.
I would just like to say, I would like to have my daughter home.
Okay.
Shania is not a bad person. It's just a misfortunate accident that has occurred Sunday night. She goes to school. She's in college. She did take a break for 1 semester so she can get a car. But however, Shania is a good person. Um, I'm just asking if she's, petitioning for her to come home, and if she can if she can have pretrial release.
Else, Mom? Okay. All right. Who else wants to speak? You don't have to, just if you want to. All right. Do you swear or affirm to tell the truth?
Yes.
Thank you. And you can put your hand down, state your name and spell your last name. Make sure you speak up a little bit and speak into the mic, okay?
Sharon Smith, Smith.
All right, Mr. Smith. And what is it you would like to tell us this morning?
I just want my sister home. Like, we family, we argue, we fight, but at the end of the day, I love her.
I can't hear him, Judge.
I know you're very softly spoken. You
sorry.
need to speak up a little bit.
At the end of the day, we're family, we argue, we fight, but I still love my sister. That's not gonna change. It just, stuff was just taken too far. I just want my sister home. She doesn't deserve this at all, not even a little bit. And I'm not in fear of my sister at all.
Are you planning on speaking? Okay. Will you raise your right hand?
Yes,
Do you swear or affirm to tell the truth?
yes,
And will you please state your name and spell your last name?
yes. Nasoma Amena Morgan Grant, Morgan Grant, Morgan -Grant. I'm Shania Smith's aunt, not only her aunt, but also her pastor as well. The person that you saw before was her brother that was the victim, and we just really want her home. This isn't her life. She's a wonderful, caring, and thoughtful individual. In school to become like her drive is also to become like a firefighter, just like myself. She has so many gifts, so many talents, and we want to see her home. We want to bring closure to our family. We want to be one. She is an amazing individual, and we're just pleading for mercy.
Mom, you had something else to say? Come on to the podium.
Thank you.
All
Sorry,
right.
Judge.
Yes, that's okay.
I was was wondering if we can do like counseling, if we get counseling in place.
Well, Ms. Morgan, that's something that can definitely be addressed, but with her division judge. That's not something I can deal with today.
Okay, all right.
Something I want to ask you is, do both your son and daughter live with you at the same residence?
Yes.
Okay. So something, we're going to talk about this more in detail, but I want you to understand when I say it. In situations like this, I almost always impose a no contact order. That is because while I understand everything that you've said to me today, and I've heard what everyone said to me, it's my job to go based off of the totality of everything I'm being given. So that includes the allegations that are in the probable cause affidavit. That's the police report, okay?
Yes.
So out of safety for everyone, I almost always impose a no contact order. That means that if they both live with you, one of them will have to stay someplace else until the issue is dealt with the division judge. You understand that?
Yes, ma'am.
Okay. All right, so what I'm going to do now is I'm going to go to the two attorneys. I will hear their recommendations, and then I'll make a decision, okay?
Okay.
Okay. All right, Mr. Linder, I'll hear
Yes,
from you.
Your Honor, I see no history. Based on the level of violence, I'd be requesting a $2,000 bond. I would be asking that the court order no victim contact. I think at a minimum, there needs to at least be a cooling off period.
Judge, reading the probable cause affidavit, the alleged victim in the case refused medical attention and indicated to the police at the time that he's not going to be prosecuting this case. I would ask the court to consider, for this case, based on the fact that it's a family squabble that clearly got out of hand, I would ask the court to consider a no harmful contact order.
Go ahead, Mr. Romero.
Judge, as you heard, Ms. Smith has no prior contact with the criminal justice system. You heard personally from the brother, he is not in fear. He wants his sister home, so obviously the family do want contact. Now, I understand the state's request, and I understand the allegations. They do live together. I did advise Ms. Smith, due to the domestic situation and what the court has to take into consideration, there is a strong likelihood that the court will be imposing a no contact order. And since she's the one that got arrested, the court only has jurisdiction over her and not the alleged victim. So, since they do live together, there are other places where she could stay. For example, my understanding is she could stay with the aunt, or she could stay with her sister who reside in a separate place. But ultimately, the family does want Ms. Smith to return home. Judge, and to elaborate as far as what the family have said, she's working. She works at Wendy's, but besides that, she also attends Broward College. She's getting her communications degree. She wants to be a dispatcher with the firefighters department. Judge, considering she has no prior contact, she's a registered voter. She's a graduate from Plantation High School. She's 19 years old, been here her whole life. I'm going to be asking for a $1,000 bond, and I'm going to be echoing my colleague's request as far as no harmful contact. I do understand that that's kind of a legal fiction. We're not supposed to have harmful contact anyway, but Ms. Smith does, and I believe the Smith family wants me to ask the court for contact.
Thank you. Ma'am, are you here to speak on this case? Okay. Were you here when I said everything to everyone else? You were here in the courtroom?
Yes.
All right, so you've heard what I've said about everything that you can say, that you're saying can be used against you and potentially her, right?
Yes.
All right, so if you want to speak, you've heard what everyone has said today. I'm not dealing with any of the background facts. We're just dealing with bond and release. So if you want to speak, I'll place you under oath, and then I'll hear what you have to say, okay? All right, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Okay, and you can put your hand down. I'm going to ask you to speak into the microphone, speak loudly so that they can hear you at the jail. And the next thing I will ask of you is to please state your name and spell your last name.
My name is Chantel, last name Smith.
Okay, all right,
I
thank you.
am
Ms. Smith.
her oldest sister.
Okay,
I'm willing to take her in to remove her from the situation. That way there's no more conflict, because again, we are family, we do fight, but I want to keep her on the correct path. So I would like to take her in if it does come to having no contact.
okay, all right, thank you, Ms. Smith, I appreciate that. All right, based on the circumstances, I am going to impose a $1,000 bond. However, I am going to impose the no contact order at this time. I understand that things happen. In this case, I understand families fight, but this isn't just a simple squabble since it involved a kitchen knife. I'm going to impose the no contact order. So Ms. Smith, this is important for you to understand because you're the one that's here before the court today. You've heard what your family members have said this morning. I need to know that you understand, for the time being, no contact means no being in the same place at the same time as the alleged victim. That includes no phone calls, no text messages, no third-party contact, and no social media contact with him. Do you understand that?
Yes, Judge.
All right, thank you very much. And thank you to Ms. Smith's family members for being present. All right, thank you. Good luck. Okay. Thank you. I have a note on here. I have someone signed in on Cesar Gonzalez's case. They stepped outside? Okay, all right. Okay. Okay, when he comes back in, just, oh, here we go. All right. All right, counsel. Good morning. Are you here on Cesar Gonzalez?
yes.
Okay, all right. Mr. Romero, do you have Cesar Gonzalez? He's on page 6.
Yes, Judge, we do.
Okay.
Mr. Gonzalez, he's here.
His-
There's your private attorney.
His private attorney and his wife are both present in the courtroom. All right, good morning, Mr. Gonzalez. You're before the court this morning on 3 charges. Count 1 is aggravated battery, where offender knew or should have known the victim was pregnant, domestic violence. Count 2, domestic battery by strangulation. And count 3 is obstructing or depriving of means to protect or communicate. I find probable cause for these charges. Your private attorney is present in the courtroom with me, and I'll hear from the parties at this time.
Judge, the listed victim is here. She is not going to be a cooperative witness for the state. I could tell you that. I know she's met with the Victims Advocate Unit. I know I would ask that the no contact order be lifted. He's the father of her child. She's pregnant. Ask that the bond be set. The funds are very limited at a total amount of $1,000 per count, which would be a total
How
bond
mu-
of $3,000.
3,000.
And if Your Honor doesn't want to address the stay away order now, I could do it in front of Judge Joel Spector, but.
Well, I can tell you I will be imposing a no contact order.
Okay.
So you can handle that with the division judge. Mr. Linder?
Yes, Your Honor. Mr. Gonzalez's criminal history includes 2014 possession of hydrocodone and cocaine, 2008 possession of cocaine with intent to sell, possession of cannabis with intent to sell, possession of a firearm with the serial number removed. He violated probation, was sentenced to 4-year state prison. 2008 aggravated assault with a firearm, carrying concealed firearm with a violation of probation, 4-year state prison. Your Honor, I can also advise the court, our victim advocate was advised by the alleged victim that there has been previous violence in the relationship. I am also greatly concerned. She also advised us that she does not want to prosecute, she's not in fear, but I would direct the court's attention, I know the court's already aware, that she allegedly told law enforcement that she essentially made statements to them voicing that there was no concern, essentially based on threats made by Mr. Gonzalez, and that she was forced and pressured to make statements to law enforcement. I have great concern going forward in this case that he may, even if the court issues a no contact order, that he may continue to interfere in the process by trying to influence her. Your Honor, based on the allegations and his history, including priors for violence, unlawful possession of a firearm, I'm going to be requesting $10,000 bond on 1, $10,000 bond on 2, $2,500 bond on count 3, pretrial release of the GPS monitor, and no victim contact.
Judge, that seems a little punitive in nature. At this point, if the state wants to put a GPS monitor on him, then we'll do that, but release the bond. Don't make him post a bond that he can't afford. He's not going to be able to afford the $27,500 bond. So he's entitled to a bond. He's entitled to a reasonable bond. If the state's concern is his danger or risk of flight, put a monitor on him with the GPS, allow him to work, and that will assuage everyone's concerns here. But he's entitled to a bond. You're just basically keeping a man in jail who can't afford a bond. Where the listed victim is going to say she doesn't want to press charges.
Your Honor,
I hear that a lot, counsel, in domestic violence cases, and you can imagine the weight that I give to it at first appearance hearings.
Understood.
and Your Honor, if I could just briefly, my reasoning is not punitive. I'm not seeking to punish Mr. Gonzalez. My concern is the safety of this alleged victim, who he's accused of choking, strangling her. He's accused of committing a battery against her while she is pregnant, and he knew of that. I'm concerned that when she just wanted to seek safety and inform law enforcement of what happened, he attempted to pressure her to stop her. So no, I'm not just trying to keep him in custody. I'm seeking bonds against someone that has a history of violence that I believe will act as a proper deterrent to ensure there is no future violence.
Judge, the purpose of bond is to assure his appearance in court. I don't think there's ever been a failure to appear, if I'm not mistaken.
That's not the only purpose of bond.
It's all monetary at this point, Judge. If he had the funds, he'd be out, and they'd still have the same concerns. So it has to be tied to what he can afford, and I'm telling you, he cannot afford a $27,500 bond.
I
So
haven't
if-
said that I was gonna set it at that yet, counsel. You're putting the cart before the horse.
I'm just responding.
That's
to the
fine,
state.
I've heard enough. The bond on count 1 is gonna be set at $5,000. The bond on count 2 will be set at $3,000. And the bond on count 3 will be set at $2,000. If Mr. Gonzalez posts his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will be an order of no victim contact until further order of the court. And if there's an issue with those bonds, they can of course be dealt with his division judge. Mr. Gonzalez, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. Since you will be on a GPS monitor, that includes a 500-foot stay away from this person. The no victim contact order also means no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand that? Well, I need one of the deputies to turn the speaker on. Thank you. All right, Mr. Gonzalez, do you understand the no contact order?
Yes, ma'am. I got a question. You said pre-child release?
Yes,
How
sir.
am I gonna be, how am I supposed to get on pre-child release when I have nowhere else to go but my home?
Well, you'll have to find someplace else to stay for the time being. All right. Thank you.
Bye, May.
Do we have another sign in?
Yes.
Courtroom?
All right. Next will be Laborious McCoy. He has family signed in.
Yes, Judge. Mr. McCoy is at the main jail.
I'm sorry. He's on page 9. All right. Okay. Good morning,
Judge,
Mr. McCoy.
This is Mr. McCoy. What page is he on, Judge?
He's on page 9.
Perfect. Let's go.
Okay, all right. Good morning, Mr. McCoy. You're before the court this morning on a misdemeanor capias. This is related to a charge for battery. I find probable cause, and I do understand we have a family member present. Ma'am, are you here to observe or to speak this morning?
I guess observing that it's a bond and.
Okay, that's all right. I always like to inquire. Okay, so at this time, I'll hear from the parties.
Judge, this is Judge Diaz, bond for KPS. He missed a court date.
Yes.
We're not going to make any arguments. Just let Mom know that the next court date is February 20th,
Yes.
so that you're going to bond him out,
Yeah.
and you can make sure he gets to court. That's Thursday, right? So make sure he gets to court on Thursday, and everything should be fine from going forward.
All right. Is there anything further from the state?
No, Judge.
Okay, so Mr. McCoy, the bond is $1,000. Are you his mom?
Yes.
Okay, your mom is here. She says she's gonna post the bond. You have a status hearing with Judge Diaz on Thursday morning. You must be present for that hearing. You understand?
Yes.
All right.
Judge, my understanding is if Mom posts a bond, which she is, I believe that court date is gonna be canceled. Is that correct?
Let me just confirm that.
He's going to need to set new
No.
dates anyway.
My in-court clerk is telling me that this will still be on the calendar, so he'll still have to attend. All right?
Thank you, Judge.
Okay, thank you. All right, good luck. Okay, and Mr. Shate, your time has come. If we have these individuals present, I'll handle our municipal ordinance cases. The first that I have is Franklin Price on page 8.
Mr. Price, come on up. He's approaching, Judge. He's here at Main.
Thank you very much.
Sure. Is it on?
Good morning, Mr. Price.
Good morning, Your Honor.
Mr. Price, you're before the court this morning on a municipal ordinance violation for open container. I find probable cause, and Mr. Shea, your attorney, is present in the courtroom with me this morning. Mr. Shea, talk to me.
Judge, it's a time served offer. This is a second arrest of 2020, and still time served.
Okay. I do see that the officer indicated that there's some history between them, so if Mr. Price wants to resolve it today, then I will do it, but if we continue down this path, then we may not have the same thing, okay? So, Mr. Price, if you want to resolve it today, the city's offers an adjudication time served. Do you understand?
Yes, I understand, Your Honor.
All right, and do you understand what I said to Mr. Shate? If you continue to get arrested for this, then I may not be taking any pleas at first appearances in the future. You understand?
Yes, I understand.
Okay. All right. So, Mr. Price, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, Your Honor.
Thank you. And now you can put your hand down. And Mr. Price, you understand everything we've discussed so far this morning?
Yes, Your Honor.
Is anyone forcing you to resolve your case?
No, Your Honor.
Are you under the influence of drugs or alcohol?
No, Your Honor. Just the medication they've been giving me here.
Okay. Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, Your Honor.
Have you ever been treated for mental or emotional illness?
No, Your Honor.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, I understand.
All right, and Mr. Price, what plea do you wish to enter, guilty or no contest?
The no contest, please.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence is an adjudication, time served. Good luck.
Thank you very much, Your Honor.
You're welcome, Mr. Price. All right, next will be William Lauren on page 11.
Lauren.
Good morning,
morning,
Mr.
Your Honor.
Lauren. Good morning. Mr. Lauren, you're before the court this morning on a misdemeanor capias. This is a municipal ordinance violation for open container. I find probable cause, and Mr. Shate, your attorney's with me in the courtroom. Mr. Shate, what are we doing in Mr. Lauren's case?
This is the first arrest in 2000. It's going to be a time served offer from the city of Hollywood.
Okay, so Mr. Lauren, if you want to resolve the case today, the city's offer is an adjudication, time served. Do you understand that?
Yes, ma'am.
And do you want to resolve the case today?
Yes, I do.
Okay, will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes, ma'am.
Thank you, and now you can put your hand down. Mr. Lauren, do you understand everything we've discussed so far this morning?
Yes, ma'am.
Is anyone forcing you to resolve your case?
No, ma'am.
Are you under the influence of drugs or alcohol?
No, ma'am.
Do you need any more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
And do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Yes, ma'am.
All right, and Mr. Lauren, what plea do you wish to enter, guilty or no contest?
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. Your sentence will be an adjudication, time served. Good luck to you, sir.
Thank you, ma'am. Have a good day.
You're welcome, you too. And next on page 13, I have Vernon Coleman.
Good morning.
Good morning, Mr. Coleman. Mr. Coleman, you're before the court this morning on a municipal ordinance violation for trespassing. I find probable cause. Mr. Shea, your attorney's with me in the courtroom.
Judge, they're offering 30 days Broward County Jail for this. It's the 10th arrest that he's had in the 2000.
It's the, how many?
The 10th.
The 10th in this year?
Correct.
All right. Mr. Coleman, what Mr. Shade is telling me is that the only offer the city's extended to you at this time is 30 days in the county jail. So because of that, I'm not inclined to take a plea from you today. I would rather you address this with your division judge. So for today's purposes, I'm going to leave the $25 bond in place. All right. Thank you very much.
Repeat that.
Your bond is $25. The city is seeking 30 days in jail for you. So I would rather you address this with your division judge than contemplate a plea here at First Appearances.
And when is this?
I'm sorry?
I don't understand exactly what you're saying.
Your bond is $25, Mr. Coleman. The bond is $25. You can either pay the $25 or you'll be seeing your division judge soon, okay?
Oh, okay.
All right, good luck to you.
I understand. Yeah, you
Thank you,
too.
Judge.
Thank you. All right, thanks, Mr. Shea. All right. I have another.
Judge, whenever the court is ready, Mr. Mendez is here and we're ready to proceed on it.
Okay, let's go ahead and do Mr. Mendez's case then.
Mr. Mendez, come on up, please.
Does Mr. Mendez need a Spanish interpreter?
No.
No, okay. All right. Okay, good morning, Mr. Mendez.
Good morning.
Mr. Mendez, you're before the court this morning on one charge of burglary of an unoccupied dwelling unarmed. I find probable cause. And ma'am, are you present to observe or to speak?
Speak.
Okay, and who are you?
My name is Elise Bergamo Mendez. I'm his wife.
Okay, all right. So, Ms. Mendez, you may have heard some of the things that I've said this morning, but I'm just going to repeat them so that I know you heard them. First off, everything we say is being recorded and can be used against you and potentially him at a later date. You understand?
Yes.
All right, and if you want to speak, I will place you under oath. I'm just going to ask you to speak loudly into the microphone so they can hear you, okay?
All right.
All right. Do you swear or affirm to tell the truth?
Yes, I do.
Thank you. And now you can put your hand down and please state your name and spell your last name.
Elise Bergamo Mendez. Bergamo, Bergamo dash Mendez.
All right, thank you, Ms. Mendez. And what is it you would like to tell us today?
I had a call yesterday afternoon from a police officer. I was startled, and they said, "We have your husband here, we're retaining him." I couldn't really make out what they were saying because there was traffic going by. They said, "We'd like you to come and pick up his bag." I said, "Okay, where are you?" "I'm on my way." I get there, and he's in the police car, and they were very, very nice. They said, "You can go over and talk to him and take his bag." And I said, "Okay." And I said, "Well, what's he charged with?" They said, I don't know at that time if they had told me, but anyway, it was burglary in an unoccupied dwelling without a weapon.
Yes.
Here's the thing. He has a prominent business. We're church members. I have jewelry. We have no reason to steal anything. He wasn't found with anything that he had stolen. Now, he was hanging around with a bad crowd, so to speak, and he was going to a treatment program today at 3 o'clock. He has an appointment, and that's his only crime, in my opinion, hanging around with the wrong people and being at the wrong place at the wrong time. And he's nonviolent, married 11 years, we're church members. He has, business going, and if he can't come out on bond, I pay the bills because I run his business. I do all the paperwork.
Okay. All right. All right. Is there anything else, Ms. Mendez?
He has a lawyer that we know. His name's Grant Schwartz.
Yeah.
I try to get a hold of him, but I'm doing fine myself because it's nothing that we're defending. You know what I mean? He had no property that he had in his possession. He had a bag of clothes that was going to Broward Recovery Center today at 3 o'clock. So whoever he was with, I picked up his bag, and all it had in it was socks, underwear, and things of that nature.
Okay.
So, he's got a really bad bite. I don't know if it's a spider bite. That's why he was retained in medical. So it needs to be treated. I just want to take care of him. And he has a cough, so he's not feeling very well.
Okay.
I just want to get him home. I'll pay the bond, whatever it is, and move on from there.
Okay. All right. Thank you, Ms. Mendez. So now I'm going to go to the attorneys, and I'll hear from them, and then I'll make a decision,
All right.
okay?
Oh, can I say a couple more things?
Yes.
In the past, because I don't know how far they go back, he was in foster care from age, I think it was 11 to 18. His mom was an alcoholic. He had no father figure, never met his father. So when he got out at 18, of course, he got hooked up with a bad crowd, and he wound up going to prison for whatever it was, 14 counts of, I think it was armed robbery, but he was stealing for the drug addiction. Now, the drug addiction was dormant he was in prison 14 years. We're married going on 11 years. You're talking 25 years. No, nothing. He didn't get, and making money and going to church. I was the church secretary. He sang in the church. He's the music minister. So you're talking 25 years. I know they'll look at the past record and say, oh, look at this, but nothing
Okay.
after that.
Okay.
Okay,
All
you'd
right.
see it in his record.
All right. Thank you, Ms. Mendez. I
Okay,
appreciate that.
thank you.
Okay. So now, Mr. Linder, I will go to you.
Your Honor, I am going to be seeking a $25,000 bond. This was someone's home, or is someone's home.
Ms. Mendez.
Ms. Mendez already mentioned his history, but I will advise the court specifically.
Okay.
In 1994, Mr. Mendez was convicted of four separate robberies with firearms or deadly weapons. 1, 2, 3, 4, 5, 6, 7. 7 separate robberies with weapons. And 3 strong arm robberies.
What was the year on those?
It was between 1993 and 1994. He was sentenced to 16 and a half years state prison.
Okay.
In 1998, he was convicted of 3 separate burglaries of dwellings, grand theft auto, 2 grand thefts. He was sentenced to 10-year state prison. But more recently, Your Honor, in 2018, he was convicted of grand theft. He was placed on 5 years probation by Judge Fine, September 12, 2019, which means while that case was pending and he faced, if he committed a new law offense, he could face being held no bond for violating his pretrial release conditions, he allegedly committed this burglary. And there is no mention of other people involved. It was, from what I can see here, just video of Mr. Mendez entering the home of his own volition, and he was identified by a detective that had prior interaction with Mr. Mendez.
This is from June of 2019. Right?
Yes. 3 months later, he while that grand theft was going on, he pled it out 3 months later. Your Honor, there is I don't see any indication that anyone was aware of this case when he took his plea.
Judge, I understand it's written as an unoccupied dwelling, but if you read the last line of the probable cause affidavit, it's written up as an unoccupied structure. And the fact that the alleged loss was power tools and lawn equipment, I think we can read into that this was a shed and not a home.
As I would also direct the court's attention to, if you look at the offenses charged, the officer wrote burglary of a dwelling, and after review, we're not hearing just a mere investigation. After review by a case filer, it was filed as burglary of a dwelling. No, I can see right here in the supplemental report, I made contact with the victim, Bridget Holm, who advised that her residence had been burglarized. She stated her residence is currently under renovation, and last night she was staying at another location. So it would appear this was her home, Your Honor.
Okay. All right, so the state's recommendation is $25,000. Anything else?
Your Honor, considering he is additionally on probation, no. I'm not asking for a GPS.
All right, Mr. Romero.
Judge, if I heard correctly, I believe the alleged date of incident was January 2019.
June.
June 2019. One moment, Judge.
Go ahead.
Thank you, Judge. All right. In speaking, Mr. Mendez, there's no way he's going to be able to come up with $25,000, nor his wife. Judge, my understanding, he was working, he's doing interior remodeling, but unfortunately, as I believe his wife touched on, he has medical issues, which lately has impacted his ability to work and has impacted his business. So financially, at this time, from what Mr. Mendez has advised me, they're basically living off of credit card. Mr. Mendez, at most, he believes if the court were inclined to set a more reasonable bond pursuant to Mr. Mendez and his wife's financial resources, we're going to be asking for a $5,000 bond on his behalf. Now, he's been here his whole life. He's 50 years old, Judge. They live in Miami, where they've been residing at the same place for about 12 years. Judge, in speaking with Mr. Mendez, he is recalling this situation. He did apply for a public defender, but I believe in the future they are going to be hiring private counsel. But I did speak to Mr. Mendez. Some of the information that he gave me pertaining to this case is going to be very useful to speak to the assigned prosecutor with, and maybe negotiating some sort of resolution that benefits Mr. Mendez. But at this time, Judge, he's not going to be able to afford the $25,000. So we're asking for a reasonable bond of $5,000 on Mr. Mendez's behalf.
Thank you. All right. Since Mr. Mendez is currently on probation, I'm not necessarily concerned with him not appearing for future court appearances, since I'm sure he's aware failing to abide by the terms of his probation could subject him to a no bond hold later on. But I do take into consideration the fact that this is someone's home. I understand what's going on here. What I'm gonna do is impose a bond of $7,500. There will be orders of no return and no victim contact. Mr. Mendez, whether you know the alleged victim or not, whatever your knowledge of the situation is, those orders mean you are not to return to the location. And with regard to the alleged victim, no being in the same place at the same time, no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand?
Yes, ma'am.
All right, thank you.
Judge, we have a Spanish interpreter in the courtroom for Mr. Martinez on page 21 of the court's docket.
All right.
Please approach the judge.
Thank you. Did you say he's on page 21?
Yes, ma'am.
Yes.
Is that Marvin Martinez?
Yes, Judge.
Okay. All right, and for my interpreter, good morning. Do you swear or affirm to interpret from Spanish to English and English to Spanish to the best of your ability?
Yes, I swear.
Thank you. All right. Good morning, Mr. Martinez.
Buenos días, señor Martínez.
You're before the court this morning on 6 charges.
Usted está delante del tribunal esta mañana por 6 cargos.
Count 1 is for DUI, alcohol, or drugs.
Cargo 1 es manejo bajo los efectos de alcohol o de drogas.
Third offense within 10 years.
La tercera ofensa dentro de 10 años.
Count 2, refusing to submit to a DUI test.
El cargo número 2 es que rehusó a someterse a la prueba de manejo bajo los efectos.
Count 3, DUI with damage to property or person of another.
Y cargo 3, manejo bajo los efectos con daños a la propiedad o a la persona de otro.
Count 4, failure to use due care.
El cargo 4, usted falló en usar el debido cuidado.
Count 5, driving while license suspended without knowledge.
Y el cargo 5, manejar con la licencia suspendida sin conocimiento.
Counts 4 and 5 are not for magistrate.
Los cargos 4 y 5 no son para el juez de primera instancia.
Count 6 is a misdemeanor capias for reckless driving.
Y cargo 6 es una orden de captura por un delito menor, manejar descuidadamente.
I find probable cause for these charges.
Encuentro que ha habido causa probable para estos cargos.
Before I hear from the parties, I see that pretrial supervision is standing up.
Y todavía veo, antes de escuchar de las partes, que ha habido los servicios previos a juicio.
And I'll hear from pretrial at this time.
Voy a escuchar ese departamento de servicios previos a juicio en este momento.
Good morning, Your Honor. Nancy Masterson, Pretrial Services. He's currently out on pretrial for case number 19005259 CF10A for possession of Isolam.
I'm sorry, the interpreter can't hear you. Just be a little louder.
Case number 19005259 CF10A.
El señor Martínez está fuera en servicios previos a juicio en el caso número 19005259 CF10A
For possession of Isolam.
por posesión de Isolam. Isolam
Yes, and possession of Alprazolam.
y también posesión de Alprazolam.
We're requesting that his pretrial is revoked in that case.
Pedimos que se revoque el servicio previo a juicio en ese caso.
When was he placed on pretrial for that case?
¿Cuándo lo colocaron en ese servicio?
January 29th.
Enero
This year,
29.
Your Honor.
January 29th, 2020?
¿Del
Yes.
2020? Sí, del 2020.
All right, based on that request, I'm going to grant pretrial's request.
Voy a concederle la petición de servicios previos a juicio basado en lo antes dicho.
I'm going to revoke Mr. Martinez's pretrial services.
Voy a revocarle los servicios previos a juicio del señor Martínez
Once again, for the record,
y de nuevo para que conste,
That's case number 195259
Es el caso 195259
CF10A.
CF10A.
At this time, I will hear the parties' recommendations as to both cases.
En este momento oiré la recomendación de ambas partes acerca de los dos casos.
Your Honor, on count one, on the new case, I'm requesting a $10,000 bond.
En el cargo 1 el Estado pide $10,000 de fianza.
Pretrial release with a TAD monitor.
Pedimos que sean servicios previo a juicio con un monitor tag
Random testing and no driving.
y pruebas al azar y que no puedan manejar.
In addition to his open felony case, Your Honor,
Y además de su caso abierto del delito grave,
Mr. Martinez was put on probation by Judge Gottlieb 2 weeks ago
el señor Martínez estuvo puesto en bajo probatoria hace 2 semanas por el juez Gottlieb
for a DUI where there was property damage.
por un caso de manejo bajo los efectos con daños a la propiedad.
It would appear he's now in violation of that probation based on another DUI,
Y aparentemente ha violado esa probatoria basado en el otro caso.
where again there was a crash.
Y de nuevo hubo un choque.
The court should also be aware.
Y también el tribunal debe de saber,
As you can see, the reckless driving is a 2005 case.
como usted puede ver, el caso de manejo descuidadamente es un caso del 2005.
Judge Levy withdrew the capias April 29th of last year.
La juez Levy retiró la orden de capias el 29 de abril del año pasado.
And then when his arraignment was set in late July of last year,
Y cuando se le fijó el día para la instrucción de cargos a fines de julio del año pasado,
he failed to appear.
él falló en comparecer.
And again, noting that that's on a reckless driving.
Y de nuevo, eso es un caso de manejo descuidadamente.
I believe the choices Mr. Martinez is making to get behind the wheel of a vehicle
Me parece que las decisiones que ha tomado el señor Martínez de colocarse detrás del volante
is placing drivers in the community in harm's way.
Esa es una decisión que pone los demás en la carretera en una posición de mucho riesgo o de sufrir daños.
I can't even remember if I requested or not a no bond on the revocation of pretrial.
No sé si lo mencioné anteriormente, pero pido que no haya fianza en el cargo de revocarle la servicio previo a juicio.
All right, Mr. Romero.
Judge, on the case that Mr. Martinez is currently out on supervision,
En el caso que el señor Martínez está actualmente bajo supervisión,
if I heard correctly, those are simple possession offenses.
si oías correctamente, es un caso simple de posesión, es una ofensa de posesión.
Considering the totality, I'm going to be requesting a $2,000 bond on that case.
Considerando la totalidad de las circunstancias acá, pido $2,000 de fianza.
Now, it's currently before the court, Judge. I believe the state's recommendation was a $10,000 bond.
Me parece que actualmente el Estado está recomendando $10,000 de fianza.
Mr. Martinez nor his family can afford that high of a bond.
Ni el señor Martínez ni su familia pueden costear una fianza tan alta.
We're going to be requesting a $3,500 bond for that count.
Vamos a estar pidiendo $3,500 para fianza en ese cargo.
Now, we have no objection as far as the other special conditions that the state has recommended.
No tenemos ninguna protesta acerca de las otras condiciones especiales que el Estado ha recomendado.
Namely, supervision and a TAD monitor.
Principalmente me refiero a la supervisión y al monitor TAD.
Now, he's been living in our community for over 20 years. He's 34 years old.
Él ha vivido en nuestra comunidad más de 20 años, tiene 34 años de edad.
He works in construction, and on a good week, he can make about $400 for the week.
Él trabaja en construcción, en una semana buena puede ganarse $400 semanal.
Now, he lives in Tamarack with his wife and 4 kids.
Y él vive en Tamarack con su esposa y 4 hijos.
His wife works, she works at a local packing store, making about $150 a week, Judge.
I'm sorry, can you repeat for the interpreter?
His wife works at a local packing store, making about $150 a week.
Y su esposa trabaja en un negocio local empacando y se gana como $150 a la semana.
So based on the family's financial resources, that is why I'm coming up with $3,500 on this count.
Y por lo tanto, considerando los recursos de la familia en este momento, por eso pedimos $3,500 de fianza en total.
Mr. Martinez should be advised
El señor Martínez debe de estar advertido
It appears this new charge may be a violation of the probation he was placed on 2 weeks ago.
Este nuevo cargo parece ser una violación de la probatoria que se ubicó hace 2 semanas atrás.
So he could potentially be seeing a no bond hold as a result of that.
Entonces lleva la posibilidad de estar detenido sin fianza en ese cargo.
But that is not before the court this morning.
Pero ese asunto no está delante del tribunal en esta mañana.
With regard to the case that Mr. Martinez was on pretrial supervision for,
Ahora, con respecto al caso que sí el señor Martínez estuvo bajo los servicios previos a juicio,
while I understand that they are possession charges,
aunque yo comprendo que son cargos de posesión,
it appears, based on the history of charges with Mr. Martinez,
parece ser basado en el historial de los cargos del señor Martínez,
there's potentially an underlying substance abuse issue.
existe la posibilidad de que haya debajo de todo un problema de abuso de sustancias con el señor Martínez.
Because of my concerns with that issue, I'm going to place a no bond hold on the case that was on pretrial.
Y por mi preocupación con ese tema, lo voy a poner sin fianza en el caso que estaba con servicios previos a juicio.
Mr. Martinez will have to address his division judge to handle that matter.
Y el señor Martínez se tendrá que dirigir a su juez en esa división para que se encargue de ese asunto.
With regard to the case that's before me today on the new DUI,
Y con respecto al caso nuevo que está del frente de mí, con el cargo de manejo bajo los efectos,
the bond on count 1 will be set at $7,500.
la fianza en el cargo número 1 será $7,500
The standard bonds will remain in place on counts 3 and 6.
y la fianza estándar se quedará igual en los cargos 3 y 6.
If Mr. Martinez becomes eligible for release and posts that monetary bond,
Si el señor Martínez reúne los requisitos para salir en libertad y prestar esa fianza,
he'll be placed on pretrial supervision,
en ese caso lo colocaremos en los servicios previos a juicio, supervisión previa a juicio,
with a TAD monitor.
con el monitor TAD.
He will also be subjected to random drug and alcohol testing,
En ese caso será sujeto a las pruebas al azar para drogas y alcohol.
and there will be an order that he not be driving until further order of the court.
Y habrá una orden emitida que no podrá manejar hasta que haya una nueva orden del tribunal.
Mr. Martinez, do you understand those conditions of release?
Señor Martínez, ¿usted comprende estas condiciones de su libertad?
Sí, pero yo no tengo ese dinero para salir de acá.
Yes,
Si
but
quiere-
I do not have that money in order to get out.
Mr. Martinez, you're being held no bond on the other case at this time.
Señor Martínez, lo están deteniendo sin fianza en este momento en el otro caso.
So you'll have to go before your division judge to address that issue anyway.
Y de todos modos tendrá que presentarse al frente del otro juez de esa división para tratar con ese caso.
Good luck to you.
Buena suerte,
Judge.
señor.
Yes.
Before we turn the page, Mr. Romero, could you ask Mr. Martinez if he wishes to do
So,
the substance abuse program while he's in custody?
Yes.
Okay, I'll, Judge, move for an order allowing him to do SAP.
yes, I'll sign that order.
Pido una orden para que pueda
Wait,
participar en SAP.
Mr. Romero,
Espere.
Mr. Martinez, I have notified your attorney Felipe Jaramillo
Señor Martínez, me he
of
comunicado
this
con
new
su,
arrest, and I'm sure he'll be getting in touch with you shortly.
me comuniqué con su abogado Felipe Jaramillo acerca de este nuevo arresto y él se va a comunicar con usted.
Thank you. All right. Do we have any other cases at Maine that require a Spanish interpreter?
No, Judge. Not that I'm aware.
Okay. I won't hold you to it. All right. Is there anyone at Paul Ryan Contier North Broward that requires an interpreter? Okay. All right. Thank you. Okay. We'll find out. All right. I do have a case that has someone signed in on it on page 5, Victoria Fredestin.
She is here present, Judge, in Maine.
Thank you. Is she- Oh, she has an attorney. Who's her attorney?
Detective's here.
Oh, well, you guys got to put that for me instead of attorney. All right. Good morning, Ms. Fredestin. I'm being told it's the detective that's present, not private counsel.
What's that?
She is on page 5. All right, Ms. Fredestin, you're
Oh.
before the court this morning on 2 charges.
Your Honor?
Yes.
May I approach, well, I don't know if you had the full warrant, I know my copy only had a couple pages, the affidavit, but only a couple pages of the actual warrant.
I think I do have the entire warrant, but let me see what you have to make sure I'm not missing anything. It's 2 pages, right?
No.
Or no, that's the warrant, excuse me. I have the other one. Thank you. All right. Yes, I did have this. Okay. All right, thank you. Okay, Ms. Fredestin, you're before the court on 2 charges. Count 1 is for making a false report concerning a bomb or explosive. Count 2 is for second-degree petty theft, first offense. I find probable cause for these charges, and I will hear from the parties at this time.
Your Honor, one moment. I can advise the court that Ms. Fredestin has no criminal history. That being said, I think these allegations are extremely serious and have to be taken extremely serious. Detective Brugman from Broward Sheriff's Office Threat Management Unit is present. He authored the affidavit. I know he has concerns also. At this point in time, I would ask the court to keep the bonds that Judge Garcia would in place. I think this is a situation that is appropriate for a more thorough, detailed bond hearing than we really can have in first appearance if the defense seeks modification. I would also be requesting pretrial release of the GPS monitor, no return to the Port Everglades until further order of the court, and I would also be requesting an order that Ms. Fredestin not be in possession of any firearms, weapons, ammunition, or explosive devices. Nothing further, Judge.
Yes.
Hello?
I'm going to argue there's no probable cause to hold her on this
Mr.
charge.
Miller, I'm just going to stop you. Probable cause has already been found by Judge Garcia Wood.
Well, then she should be released on her own recognizance because, Judge, the charge is false report concerning planning a bomb. Okay, what I've read in this probable cause affidavit is that this woman spouted off to some person, okay, and that the alleged threat was, I'm going to blow this place up. There's no report of placing a bomb.
That's why it's a false report.
No, it's unlawful for a person to make a false report with the intent to deceive, mislead, or otherwise misinform any person concerning the placing or planting of any bomb. So she's not saying, I planted a bomb and I'm going to blow this place up. She just said, I'm going to blow this place up. That's not the same. You're missing that element of actual placing of the bomb. This is just someone spouting off, being angry at being fired because the person who came to relieve her from her post was delayed.
From what I'm seeing in this probable cause affidavit, she is an ex-security guard for Port Everglades who was fired, failed to return her security ID, which provides her with access to the entire port. And yes, I understand that she, as you have said, spouted off, but making a statement like this in the position that she is in and the location that she is in this day and age has to be taken seriously.
Yes, Judge,
So
but
I'm going to deny the request. She is not going to be receiving an ROR today. I'm upholding Judge Garcia's finding of probable cause. And at this time, I'm going to hear if Mr. Romero or yourself have any other recommendations for bond or release conditions, then I will hear them at this time.
Judge, certainly the bond that's currently before you, $100,000 and $5,000 for Ms. Fredestin is tantamount to no bond. As you heard from the state, she has no prior criminal record. She's a registered voter. She's 23 years old. As my colleague stated, for mitigation purposes, I know probable cause has already been found. This is this is certainly one of those cases that I believe she was spouting off. Now, I am aware, as far as the state's concerned, the court's concerned, in the day and age that we're living in, we have to take these things seriously. But still, we cannot forget, and we sometimes when people are faced, they're terminated or something like that, they just mouth off. And I think this is the case. She was just simply mouthing off. Now, she was working for this company, in which now she's been terminated, making only $11 an hour. She lives with her boyfriend in Fort Lauderdale, where they rent, they do not own, and their monthly rent was approximately $800 a month. The only person that can post her monetary bond is her boyfriend that works at a car wash. I mean, judging from what Ms. Fredestein was making, about $11 an hour, judging from what her boyfriend makes at a car wash, it's probably going to take over 10 years for them to come close to coming up with this $100,000 bond. That's why I'm using the term. This is tantamount to no bond for her. Now, something more reasonable, considering the circumstances, consider her strong ties, her lack of any criminal priors, I'm asking the court to consider a $5,000 bond. We will not object to having her placed on level 2 supervision. So she'll be supervised, she'll have a monitor on her, and a financial bond. I believe that's reasonable considering these allegations, Judge.
I think there's a difference between someone working at a fast food restaurant, for example, and spouting off and saying something like this, and someone who works security at a location like Port Everglades who has access to the entire port saying something like this. So taking into consideration the circumstances of the situation, this obviously makes it a more serious allegation. One question I'm going to pose to the state, since I know the detective is present, is has the port identification card been recovered?
Yes, Your Honor.
All right.
Yeah, Your Honor, I'm being advised it was obtained when Ms. Fradiston was arrested. She did keep possession of it, though, from the time of the alleged incident till she was arrested, and that would have been, yesterday? Okay. Yeah.
Your Honor, I'm reviewing the jury instructions for this charge. And again, it requires that there be a report of the placing of an explosive device, not just the threat, which is all that's present here today.
Your Honor, may I address this real quick, just for record purposes? First, Judge Garcia would found probable cause, but even if she didn't, I would direct the court's and Mr. Miller's attention to 790.162, threat to throw, project, place, or discharge any destructive device. It is unlawful for any person to threaten to throw, project, place, or discharge any destructive device with intent to do bodily harm to any person or with intent to do damage to any property of any person, and any person convicted thereof commits a felony of the second degree. So it's the same level as the offense that she was arrested for. There's no consequences if convicted aren't any less severe. So I think the court can proceed even under a theory of 790.162 and remain in the same position we are at this moment.
I also just want to note, because of the statements made by the defense today, while I understand the circumstances and why the statement was likely made, in the affidavit, it states, due to the defendant's threats and location of the threat, the U.S. Coast Guard had to be alerted to the threat made by the defendant. These circumstances make this a more serious issue. That's a given. So based on what I'm seeing, I'm going to leave Judge Garcia's bonds in place as set by her, and if there needs to be a bond hearing, then I think it's going to need more in-depth testimony and more time, and that can be given by the division judge. So for today's purposes, I'm going to leave those bonds in place. If a monetary bond is posted, Ms. Fradiston will be placed on pretrial supervision with a level 2 GPS monitor. There will also be a no return order that applies to Port Everglades until further order of the court. And there will be an order that Ms. Fradiston possess no weapons, firearms, or ammunition. Ms. Fradiston, that means if you are in possession of any weapons, firearms, or ammunition, they are to be surrendered to local law enforcement until further order of the court. Do you understand that?
Yes.
Thank you.
Eric Linder.
All right, I have private counsel signed in on Stanley Charles's case. He's on page 24, so I'm not sure if he's present yet. He's there? He's at Conti?
Oh, Conti.
Okay.
With the original conflict counsel.
Oh, okay. All right, Mr. Weintraub, thank you.
This has been going to, I believe, be signed to one of our attorneys.
Okay, let me go over to Conti and see. Conti, do you have Stanley Charles?
Your Honor, if I could have a moment also to talk to counsel.
Go ahead.
I'm looking for it. There's two of them.
I'm sorry? 2 cases? Is he in 2 places on my docket?
Page 15.
Stanley Charles.
Yes, Your Honor.
All right, good afternoon, or good morning, Mr. Charles. Give me one moment just to get your paperwork. Not sure why I keep getting 2 packages.
On page 15.
I know, I have him on 2 places on the docket is what the clerk is telling me. I think it's because there's an add charge and a change of charge.
On the last page of the docket as well.
Oh, was that him? So why does it say bond surrender? All right, well, I'm gonna check with you before I sign these 2. No, I don't.
Yeah, well, I know he has, well, there's only one for the one case
Okay,
for the docket.
so Mr. Charles is in 2 places on our docket. In one packet, I have an add charge, and there's also an indication there may be a change of charge. And on the other paperwork, I have a bond surrender. So somebody tell me what's correct.
Your Honor, well, they're both correct. Your Honor, what I was going to be requesting, I was just talking to counsel.
Yes.
Mr. Charles was originally arrested on an aggravated battery with a deadly weapon.
Yes.
He was out on bond. His bond was surrendered. He was also ordered to be held no bond. Judge McHugh revoked his bond on a pending battery case, and I believe Mr. Weintraub is representing him on that misdemeanor case. The state, the assigned ASA to this case, filed a motion for pretrial detention in front of Judge Lynch.
Okay.
That was supposed to be heard yesterday at his arraignment. The PD filed a motion to withdraw on that case. My understanding is, and I spoke to Mr. Farbarek who filed the motion, he advised me that was granted also.
Okay.
I spoke to Regional Conflict Counsel this morning. They haven't gotten an order appointing them on that felony case. What I discussed with counsel, and if it's acceptable to the court, the next hearing date for his domestic violence case is February 26th. Mr. Miller has advised me that the hearing from yesterday, the pretrial detention, was reset for the 24th. Is that's your understanding, Mr. Miller? Okay. Since he can't get out at this point before the 26th anyways, and there's already a motion filed before Judge Lynch, I was going to be asking if the court could keep these at no bond and let it, he suffers no prejudice since ultimately Judge Lynch, one way or the other, is going to be ruling on the motion for pretrial detention. And
Is there any objections?
I don't have an objection at this time, Your Honor. I just would request that would we be setting this hearing for the 24th?
my understanding is it's already been set for the state's motion for pretrial detention. Obviously, if Judge Cogdell does this today, it would be without prejudice, and it's just up to Judge Lynch how he wants to proceed.
All
Your
right.
Honor, at this time, I would not have an objection. Just ask this be reset to the 24th.
That's fine. So based on what Mr. Charles has going on, since he has to go in front of the judge on the 24th anyway, that's fine. So the next thing that I need to pose to everyone is, since I have 2 finding sheets here, I want to make sure the information is correct so that the division judge knows what's going on.
Yeah, and I'm going to be speaking to the ASA side of the case.
Okay.
Essentially, the reason I think there's 2 finding sheets is because he was booked on the change of charge,
All right?
and then he was booked on the bond surrender.
Yes. All right, so are we indicating no bond on both of them?
I would just ask for simplicity that the court take that.
Fine. All right, that's fine. I will indicate that on here. And Mr. Charles, since your hearing on the 24th was already set, that's going to remain the same. So you're going to see the division judge on the 24th so that you can address the other motion that's pending, all right?
Okay.
Okay, all right. So I'm indicating no bond on both of them. And his division judge can address that on the 24th. All right? Okay, thank you very much. Mr. Charles, good luck.
Thank you.
You're welcome. Thank you. All right. So now going to our regular list. Next will be Don Dwyer. Shit. Thank you. All right. Good morning, Ms. Dwyer.
Good morning.
Ms. Dwyer, you're before the court this morning on one charge of aggravated assault with a deadly weapon without intent to kill. I find probable cause, and I'll hear from the parties at this time.
One moment, Judge. Your Honor, I'm showing priors for dealing in stolen property and false ownership info on a pawn item, 2014. Possession of cocaine, 2011. Based on the level of violence, and I believe was a witness to the incident, I'm requesting a $5,000 bond, no victim contact.
Mr. Romero?
Judge, in speaking to Dwyer, as you heard, she does have prior contact with the criminal justice system, but my understanding, she's been clean for the past 6 years. I believe this is the first time she's been picked up on a, which is termed like a domestic situation. Having said that, she's been living in South Florida for 10 years. She's 49 years old. She does work, and what she does is basically she's a caretaker. She basically takes care of one of the individuals that resides at that location. Now, that is not the alleged victim. It's someone separate. The person that she takes care of, my understanding, he's the homeowner, and he rents out those premises to the alleged victim, which basically moved in there about 3 weeks ago when he was released from incarceration. And speaking with Ms. Dwyer, she's been advising me that she's contacted law enforcement on that individual to report issues regarding abuse. My understanding in this situation here, both individuals contacted law enforcement. Now, having said that, Judge, one of her benefits as far as taking care of that individual that resides there is free rent, but unfortunately she has no sort of income. So as far as monetary bond, she really cannot afford anything at this time. Now, I did advise her the court is going to order a no contact order. If that person is still there, I told Ms. Dwyer she cannot go back there or else she'll be rearrested. Now, she needs to go back there at least for the purposes, one, of I believe she has pets at the premises to retrieve those pets. So I'm going to ask for a one-time return with law enforcement to retrieve her property. Also a photo order so we can photograph the injuries that Ms. Dwyer sustained from the alleged victim. But at this time, Judge, she has no one to help post her monetary bond.
All right, her bond's gonna be set at $1,500. There will be an order of no victim contact. If Ms. Dwyer does need to return to the premises one time to retrieve her personal belongings, she must do so with local law enforcement. And I will sign the photo order that was requested.
Thank you, Judge. I'm preparing that now.
Thank you. Princess Butler. Good morning, Ms. Butler. You're before the court this morning on 2 charges. These are both misdemeanor capiases. They relate to charges for petty theft and criminal mischief. I find probable cause, and I'll hear from the parties.
Judge, at this time, nothing to add from the defense.
Anything further from the state?
No, Judge.
All right. I do see Ms. Butler has a status hearing with her division judge tomorrow morning, just so she knows. Thank you. Kitty Parker,
I've been advised bonded.
thank you. Melissa Given,
I believe North Broward.
Broward, Judge.
okay.
Good morning, Your Honor.
Morning, Deputy.
Who are we looking for?
Melissa Given.
Given. Come on.
Judge, Ms. Given has indicated to me that she would like to resolve this case if the court is so inclined.
Okay. Thank you. Good morning, Ms. Given.
Morning.
Ms. Given, you're before the court this morning on one charge of trespassing on an occupied structure or conveyance. I find probable cause. And Mr. Linder, does the state have a plea offer for Ms. Given?
Offer be withhold court costs, no return.
All right. Ms. Given, if you want to resolve the case today, the state's offer to you is a withhold of adjudication plus court costs and a no return order to the location of incident. Do you understand that?
Yes.
And do you wish to accept that offer today?
Yes.
All right. Will you please raise your right hand? Do you swear or affirm to tell the truth?
Yes.
Thank you. And now you can put your hand down. Ms. Given, do you understand everything we've discussed so far this morning?
Yeah.
Is anyone forcing you to resolve your case?
No.
Are you under the influence of drugs or alcohol?
No.
Do you need any more time to speak with your attorney?
No.
Do you understand that you have the right to trial, but you are waiving that right by taking a plea today?
Yeah.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
Okay.
You understand that, Ms. Given?
Yeah.
All right. And what plea do you wish to enter, guilty or no contest?
No contest?
All right. I accept your plea and find that it's freely and voluntarily given. As we discussed, your sentence will be a withhold of adjudication plus court costs, and there will be the no return order that we discussed. And you understand that?
Yeah.
All right. Good luck to you, Ms. Given. You'll be released later today if there's nothing else holding you.
All right. Thank you.
You're welcome. Pamela Faust.
Yes.
Good morning, Ms. Faust.
Good
Judge,
morning.
we have an argument as to counts 1 and 2.
All right. Ms. Faust, you're before the court this morning on 2 charges. Count 1 is DUI, alcohol or drugs, first offense. Count 2 is DUI with damage to property or person of another. And Mr. Linder, I'll hear your argument at this time.
Judge, so Ms. Faust is identified as the driver of vehicle 1 in the
Yes.
probable cause affidavit. However, there is nothing in the probable cause affidavit that actually places her behind the wheel. So there being no wheel witness, there is actually no one who can testify, or according to this PC, that she was the one actually driving the car. And so I would argue there is no probable cause for either count.
Well, I do see on the second page of the PC affidavit, the second full paragraph, it says, 2 sentences in, while speaking with the driver who was identified via her Florida driver's license as Miss Pamela Faust, he observed the following indicators of impairment, and then it goes on from there.
Yes, ma'am, and that's what I was referring to.
Yes.
She was being identified as the driver.
Right.
But there is no one who is saying they saw her driving. So this is conclusory without any facts supporting it.
Okay, Mr. Linder, you have a response?
I would agree with the property damage, but not with the DUI. I think the information provided by Sergeant Zeller, considering noting that the car was in drive, She was in the vehicle, Your Honor. I don't think it's conclusory to say at that point he was speaking with the driver. I would agree to say that she was the driver when the accident occurred. Without a wheel witness, you would need a wheel witness, but driver has a plain definition in the context of the second paragraph, Your Honor.
And Judge, I'm reading this a little differently.
Okay.
What I'm seeing is that Sergeant Zeller saw the vehicle facing the wrong way in the lane, and the vehicle was still running and in drive, but it doesn't say that she was behind the wheel.
It says while speaking with the driver, he couldn't have been.
Again, that's conclusory.
If I may, he wasn't. It's not reasonable to believe he was speaking to her from a moving vehicle. He was speaking to her after the car was in drive but not moving. If she's the driver, it's implicit in the definition that she's in the driver's seat, Your Honor. That's why I note it's relevant to note that the car was in drive, because that would mean she's in actual physical control of the vehicle.
That's
I do see later
not within
on,
the four corners of the.
later on in the probable cause affidavit, Officer Sapp does note that she was in the driver's seat of the vehicle during the DUI investigation. So I'll find probable cause for count 1 and no probable cause for count 2. So she'll be ROR'd on count 2. And I'll hear the party's recommendations as to bond on count 1.
Judge, I spoke with Ms. Faust earlier today. She can afford the bond, so would ask the court to keep it as set.
All right. Anything further from the state?
No, Judge.
All right. So Ms. Faust, your total bond is $500. Good luck to you, ma'am.
And Ms. Faust, I did contact your employer and advise them that you would not be in this morning.
Thank you.
All right. Next will be Federica Boyd. Thank you. This is an ad charge.
Yes, Judge, I spoke with Ms. Boyd earlier this morning. She was concerned at this, how this got to be an ad charge. So it turns out they filed the information, they added a second count, there was a second alleged victim in the case. We would just ask the court to set a minimal bond. The bond in count 1 is $150,000, and she has a no bond hold. She's not going anywhere.
All right. So Ms. Boyd, just for the record, you're here on an ad charge this morning. As I'm sure you discussed with Mr. Miller, this is an additional charge for robbery with the weapon. I do find probable cause. And Mr. Linder, what does the state have to tell me?
She had a $2,000 bond set on a separate robbery weapon. I'm fine with that same bond being placed on this count.
2,000?
Yes.
All right. Mr. Miller, you have any objection to that?
No objection.
All right. So the bond on this count will be set at $2,000. All right. All right. Thank you, Ms. Boyd. Good luck. Okay. Next will be Jovanisha Miller.
No problem.
Thank you. All right. Good morning, Ms. Miller.
Good morning.
Ms. Miller, you're before the court this morning on 2 charges. Count 1 is grand theft auto. Count 2, operating without a valid driver's license. I find probable cause, and I'll hear from the parties at this time.
Judge, we're just asking the court to keep the bond as set.
All right.
Asking the court to raise the bond to $5,000. Ms. Miller, from what I could tell, if I could just have one moment, I just want to see.
Go ahead.
Your Honor,
Yes.
Ms. Miller was just placed on 2 years probation 4 days ago, last Friday, for 2 cases, strong arm robbery and grand theft auto. The Department of Corrections hasn't even had time to put it on in the database. That's why she doesn't have a 94806 hold on her right now.
What were the charges in that case?
One case was grand theft auto. The other case was strong arm robbery. Odyssey doesn't even, they have the disposition, but they don't even have an updated to show that she's on probation.
All right, well, Ms. Miller, if that is indeed true, then you will probably have a probation violation coming down the line. Those usually have a no bond hold. So,
I understand that.
okay. All right. So what I'm gonna do is, I'm going to set the bond in this case, excuse me, at $5,000. And if if the violation of probation comes up, then Ms. Miller will go before your division judge to address that matter, all right? Good luck, ma'am. Okay, next will be April Hollis.
Judge, hear me?
Thank you. All right, good morning, Ms. Hollis.
Hi, good morning.
Ms. Hollis, you are before the court this morning on 2 charges. These are each a separate charge for second-degree petty theft, third or subsequent offense. I find probable cause, and I'll hear from the parties at this time.
Judge, in speaking to Ms. Hollis, she's not going to be able to afford to post a monetary bond. She did advise she has prior contact with the criminal justice system, but nothing recent. Right now, she's currently applying for disability. She lives with her mom in Boynton Beach. She's a housekeeper and cannot afford to post this monetary bond. So I'm asking the court to consider releasing her under pretrial release.
History includes theft from 9 months ago, 2015 felony theft, VOP, 13-month state prison, 2014 felony theft, VOP, 13-month state prison, felony theft 2013, theft 2013, theft 2012, felony theft 2012, felony theft 2011, theft 2010, theft 2010, loitering and prowling 2010, grand theft 2010, theft 2010, theft 06, theft 05, theft 04. She has multiple other priors, Your Honor. I'm just mentioning the theft-related priors.
Judge, if the court is concerned, consider Ms. Hollis's prior record. I'd even ask the court to entertain, if the court's not inclined for standard, I'd ask the court to consider a level 2 pretrial.
Mr. Linder, you have anything further to add?
No, Judge.
All right. Mr. Romero, I'm going to grant your request for a level 2 GPS monitor. That means, Ms. Hollis, you'll be ROR'd on counts 1 and 2 and released to pretrial supervision. Since you're going to be placed on a level 2 GPS monitor, Ms. Hollis, that means that someone from pretrial will come to you to fit you for the GPS. There will be a no return order. Both incidents in this case relate to the same Publix that's at 2633 North Dixie Highway. That means that you're not to return to that location. Do you understand?
Yes, ma'am.
All right, thank you. All right, next will be Lorenzo Rodriguez.
He's approaching, Judge.
Thank
Me?
you. Good morning, Mr. Rodriguez.
Good morning.
Mr. Rodriguez, you're before the court this morning on 2 charges. Count 1 is touch or strike battery, domestic violence. Count 2, tampering in a misdemeanor proceeding. I find probable cause, and I'll hear from the parties at this time.
Your Honor, I'm requesting a $1,500 bond on count 1, a $1,000 bond on count 2. He was arrested 2016 for domestic violence battery by strangulation and domestic violence battery.
Judge, that's reasonable.
Okay.
All right, there's also going to be a no contact order. Based on the probable cause affidavit, Mr. Romero, you can discuss this with him further. It appears that he does reside with the alleged victim, who is his mother. So, Mr. Rodriguez, so that you understand the no contact order, if you do reside with your mother, that means that you'll have to find someplace else to stay, because no contact means no being in the same place at the same time. It also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand?
Yes.
Thank you. Next will be Syed Shah.
He's approaching, Judge May.
Thank you. Good morning, Mr. Shah.
Good morning.
Mr. Shaw, you're before the court this morning on 3 charges. Counts 1 and 2 are touch or strike, battery, domestic violence. Those are 2 separate charges. Count 3 is an ad charge for an immigration hold, which has a no bond hold on it. I find probable cause, and I'll hear from the parties on counts 1 and 2, but Mr. Shaw, just so that you understand on the immigration hold, which as I said has a no bond hold, you'll have to go before an immigration judge to address that matter. Now at this time, I'll hear from the parties with recommendations for 1 and 2.
No history, Judge. I'm requesting a $1,500 bond on each count.
All right,
I'm sorry, how much did it say ask for?
$1,500 for each one.
That's reasonable, Judge.
All right. There's also going to be a no contact order. Mr. Shaw, so that you understand, the no contact order means you're not to have any contact with either of the alleged victims in this case. That means no being in the same place at the same time. If you reside together, that means you'll have to find someplace else to stay for the time being. No contact also includes no phone calls, no text messages, no third-party contact, no social media contact. Do you understand, sir?
Yes.
Thank you.
I don't think it's on the next.
Next will be Anthony Jackson.
He's approaching, Judge.
Thank you. Good morning, Mr. Jackson.
Good morning.
Mr. Jackson, you're before the court this morning on 5 charges. Count 1, robbery by sudden snatching without a firearm or weapon. Count 2, burglary of an occupied dwelling unarmed. Count 3, stalking, dating violence. Count 4, second-degree petty theft. Count 5, false imprisonment. I find probable cause for these charges, and I'll hear from the parties at this time.
Your Honor, first off, Mr. Jackson was arrested for battery against the same alleged victim last year. That was dropped. He was arrested for domestic violence battery in 2013 against a different alleged victim. That was dropped. He was also arrested in 2012 for aggravated battery against a pregnant victim. That was dropped. That was the same alleged victim as the 2013 case. One moment, Your Honor. Yeah, that's the injunction form in the middle. That's the DV case that was dropped. Your Honor, based on the history and the allegations in this case, I'd be requesting a $5,000 bond on count 1, $15,000 bond on count 2, a $10,000 bond on count 3, a $5,000 bond on count 5. Also noting the victim's 3-year-old son was present during this incident, and she was not only prevented from leaving the home for her own safety, but her child's safety. Also noting that there was that it appears the victim has obtained an injunction seeking protection from the courts from Mr. Jackson. So I'd also be requesting a GPS monitor, no victim contact.
Judge, I believe my math is correct. The state is asking for $35,000 bond. Mr. Jackson cannot afford that. He's 28, been here his whole life. He's been working for the same employer for 6 years now. He works at a convenience store where he works behind the counter register and stocking. He makes about $13 an hour. He lives in Lauderhill with his mom. My understanding is his mother does know he is here. She will be helping him post his monetary bond. My understanding is she works at Taco Bell and cannot come up with the $35,000 bond. I was going to be requesting on count 1, the court consider setting a $2,500 bond. On count 2, I was going to ask for a $5,000 bond. On count 3, I was going to ask for a $2,500 bond. And on count 5, I was going to ask for a $2,000 bond. So our total request is about $12,000 on Mr. Jackson's behalf, Judge.
Jackson. Oh, because it's.
The bond on count 1 will be set at $2,500. The bond on count 2 will be set at $15,000. The bond on count 3 will be set at $10,000. The bond on count 5 will be set at $2,500. If Mr. Jackson does post his monetary bond, he will be placed on pretrial supervision with a level 2 GPS monitor. There will also be an order of no victim contact. Mr. Jackson, so that you understand the no contact order, that means you are not to have any contact with the alleged victim in this case. If there is a permanent injunction in place, then that should go without saying. But so that we're clear, since you'll be wearing a GPS monitor, that will include a 500-foot stay away from this person. The no contact order also means no phone calls, no text messages, no third-party contact, and no social media contact. Do you understand that, sir?
Understand.
Thank you. Jason Nichols.
He's approaching, Judge.
Thank you. Good morning, Mr. Nichols.
Good morning, Your Honor.
Mr. Nichols, you're before the court this morning on 2 misdemeanor capiases. These are each related to 2 separate charges for operating with a suspended driver's license. I find probable cause. I do see that you're set to have a hearing with your division judge tomorrow morning. Yes, Mr. Romero?
Judge, Mr. Nichols wanted to resolve this, so we wanted to see if the state had a plea offer for him today.
One moment.
Go ahead.
I'm gonna need a moment to pull his driving record and see when these cases occurred, since it's 2 separate DWSs. Your Honor, I can make an offer. It would be, on count 1, adjudication time served. Count 2 would be adjudication 10 days in county jail. I'm showing a previous DWLS from 2007. And this, according to the citation, this DWLS on count charge 2 occurred December 11th, 2019.
Judge, at this time, considering the 10 days, he's going to see his judge tomorrow, so nothing to add.
Okay. All right, I'm going to leave the bonds in place, and Mr. Nichols, you'll see your division judge tomorrow morning. Thank you. Next will be Thomas Tate. Good morning, Mr. Tate.
Hello, good morning.
You're before the court this morning on 1 charge of touch or strike battery. I find probable cause, and I'll hear from the parties.
Judge, anything to add from the defense?
All right.
Just request no victim contact.
All right. I will leave the standard bond in place. Also impose an order of no victim contact. Mr. Tate, so that you understand the no contact order, that means no being in the same place at the same time as the alleged victim. That also means no phone calls, no text messages, no third-party contact, and no social media contact with that person. Do you understand?
Yes, ma'am.
Thank you. Walford Folks.
Bonded, Judge.
All right, thank you. Omar Payret.
He's approaching Judge Main.
See, I know you don't put anything. He was driving.
Good morning, Mr. Payret. Mr. Payret, you're before the court this morning on 2 misdemeanor capiases. These each relate to a charge for trespassing. I find probable cause, and I'll hear from the parties.
Judge, Mr. Payret wanted me to ask if the state had a plea offer for him today.
Okay. Your Honor, to resolve both cases, the offer from the state is 15 days county jail. Frankly, the ASA assigned to the case offered him a year's probation. I'm not relaying that because frankly, that's setting Mr. Payret up for failure. I don't believe he could possibly successfully complete a year's probation.
Okay. All right, so I'm gonna leave the bonds in place at this time, and Mr. Payret will see his division judge. Thank you.
Someone else's.
Courtney Gordine.
Mr. Gordine? He's approaching Judge.
Thank you. Good morning, Mr. Gordine.
Good morning.
You're before the court this morning on 2 traffic capiases. These relate to charges for unlawful license tag or sticker and reckless driving. I find probable cause, and I'll hear from the parties.
Judge, it's me, Mr. Gordine. He wishes to resolve this matter. We want to see if the state had a plea offer for him.
No, I can't really make an offer on the reckless driving with, it looks like there was a crash. If he, I mean, it's not much, but I can definitely make an offer on charge number 1 to reduce the bond by $50.
Let me talk to him, Judge. Judge, he's going to just find out.
Okay, I'll leave them as they are. Thank you. Ronald Benson.
Judge, I've been informed he bonded.
All right. Craig Sirota.
Mr. Sirota, come on up, please.
Good morning, Mr. Sirota.
Morning.
Mr. Sirota, you're before the court this morning on 3 charges. Count 1, DUI, alcohol or drugs. Count 2 is for speeding. 3 is for having an expired tag. Counts 2 and 3 are not for magistrate. I find probable cause, and at this time I'll hear from the parties on count 1.
Judge, I'm just going to be requesting a property order so you can self-bond.
Okay, I'll sign that order. Thank you. Next will be Andrew Horvath.
He's approaching, Judge.
Good morning, Mr. Horvath.
Morning, ma'am.
You're before the court this morning on 2 traffic capiases. These each relate to charges for operating a motorcycle without a valid driver's license. I find probable cause, and I'll hear from the parties.
Judge, can we check to see if his bond's been posted?
Yes, let me see. It is not showing as posted.
Nothing to request at this time, Judge.
Okay, thank you. Next will be Matthew Riskissa.
Hey, Jeff.
Thank you.
Oh, Judge, I've been advised he's a medical reset.
Okay. Anthony James. Is he
Conti,
joining?
he has refused to come to court this morning. We do represent him on this matter, and I would ask the court to allow me to waive his presence for purposes of this hearing.
Okay. I also just want to ask, according to my paperwork, is there a change of charge as well?
Yes,
Yes,
Your
sir.
Honor. I'd ask the court if you could write in the findings burglary of a structure.
Yes.
Bond was originally set at 1,000 by Judge Barner. Just requesting that that bond remain in place.
Does it matter what charge number?
It's count 10.
Oh, yeah, no, let me, Sheila, what charge number is it for BSO? Which one's 10?
10 is the burglary. Yeah, 10 is
Which one?
10. Excuse me, the burglary.
Judge, I'm joining Mr. Linder's request to keep the bond at 1,000.
Okay.
Ten is the burglary, Judge.
Okay. Are they the
17 is the theft.
same? Is it the same case number for both?
It is.
All right. Set that bond at $1,000. And we'll leave $750 on the ad charge. All right.
Thank you, Judge.
Thank you. Next will be Edward Fittimon.
Judge, Mr. Fittiman is also at Conti.
Okay.
He was not feeling well and asked if the court would allow me to waive his presence for purposes of this hearing.
That's fine with me. I have on here, I have ad charges on my finding sheet, and it also looks like there's a change of charge. Is that correct?
Your Honor, no, the change of charges were taken care of by Judge Bober over the weekend.
Okay, great.
We're just here on the ad charges.
All right, so I find probable cause, and what do you want to do with the ad charge?
Your Honor, I'm requesting that the court, he's being held on counts 1 and 2 with $25,000 and $10,000 each. I'm asking that the court set each of these at 10, but I'm also, based on the nature of the aggravated stalking, going to be requesting a GPS monitor. I can tell you, immediately after this incident, the alleged victim sought and obtained an injunction of order of protection against Mr. Fittimon, where she details the history between the two. There was also an issue, I recall.
Judge, we'll be fine with that.
Okay, all right, that's fine. So then the bond on each ad charge will be set at $10,000. And if Mr. Fittimon does post the monetary bond, he'll be put on pretrial supervision with a level 2 GPS. And I'm sure there's already a no victim contact order, but I'm gonna write it again.
Yeah, it's just, that's fine, but it is attached to the case already.
I figured. All right. Thank you. Next will be Terrence Harris.
Hey, Joe.
Okay.
He's approaching, Judge.
Thank you. Good morning, Mr. Harris.
Good morning.
Mr. Harris, you're before the court this morning on 2 charges. Count 1 is for burglary of an unoccupied conveyance unarmed. 2 is for second-degree petty theft. I find probable cause, and I'll hear from the parties.
Judge, right now, Mr. Harris advised me he's not working. He lives with his grandfather in Dania Beach. His grandfather is on a fixed income, gets Social Security. Mr. Harris has been here his whole entire life. This is a third-degree felony. We're going to be requesting a $1,000 bond on Mr. Harris's behalf, Judge.
I'm fine with that.
All right, the bond on count 1 will be set at $1,000. Thank you.
Your Honor, just ask for no victim contact, no return.
All right, hold on, Mr. Harris, hold on. There's also going to be a no return order and a no victim contact order. So, Mr. Harris, whether you know the person or not, whatever the location is this occurred at, that means you're not to return there. And whether you know the alleged victim or not, so that you understand no contact means no being in the same place at the same time as that person. It also means no phone calls, no text messages, no third-party contact, and no social media contact with that person. Do you understand?
Yes.
All right, thank you. John Slayback.
He's here, present, Judge, at me.
Thank you. Good morning, Mr. Slayback.
Good morning.
You're before the court this morning on 3 charges. Count 1, burglary of an unoccupied conveyance unarmed. Counts 2 and 3 are each felony probation violations, which have no bond holds. I find probable cause. I'll hear from the parties.
Requesting a $3,500 bond on count 1 in light of the no bond holds out of Hillsborough County. No victim contact, no return.
Judge, considering as a whole from Hillsborough, nothing to add at this time.
Okay. All right, the bond on count 1 will be set at $3,500. There will also be an order of no return and no victim contact. Mr. Slayback, so that you understand those orders, that means whether you know the alleged victim or not, you're not to return to the location, you're not to have any contact with that person. So that means no being in the same place at the same time. It also means no phone calls to that person, no text messages, no third-party contact, and no social media contact. Do you understand?
Yes.
All right, thank you. Next will be Jerry Washington.
And,
He's at the main jail, Judge. I'm looking at,
he shouldn't be.
Mr. Washington?
Yep. There's a felony
Oh,
KPS.
confinement took him off? Okay.
And that's an error. One moment. Yes, Your Honor, what happened was Mr. Washington had a pending misdemeanor case.
Yes.
He appeared in front of Judge Evans yesterday and ended up resolving the case. Now, in this felony case, when Mr. Evans was first arrested, he was charged with resisting with violence and resisting without violence. The state filed an ad charge, battery on a law enforcement officer. That created an ad charge capias. I don't know how, but that was brought to Judge Evans' attention when he appeared before him. Judge Evans ordered him to be taken into custody on the capias. He should not have, and Your Honor, if you look at the order from Judge Evans,
I see it.
It says he's to be remanded in custody pursuant to the warrant capias in case 2162 CF10A. The only capias in 2162 CF10A is the no bond hold on the battery on a law enforcement officer.
Yeah, charge.
Yeah, charge.
Okay.
He's entitled to a bond on that. Additionally, since he posted bond on the resisting of violence, it should be placed back on so his bondsman can prepare an affidavit to take care of that. But I don't believe it was Judge Evans' intention for him to be held no bond.
Right.
Even if it was, respectfully to Judge Evans, that would be incorrect because there's no court order from Judge Usan.
So we forward that back to the division so the division can say with this court order, is he setting bond or is he held no bond?
Well, it's easy for me to see on the capias, based on what it says, he should have been sent to magistrates for a bond, so,
But on the capias, Judge,
yes.
they have wrote on the front that there was no WC from Warren, which was not confirmed. So when they brought him in for court order, it should have been
I'm going to try to keep this as simple as possible. There were never any legal grounds to order him to be held no bond.
Correct.
That's really where it begins and ends.
But that's why it's going back to who issued the order. Like, we're working on it already. I didn't bring it back. I'm not gonna like that this morning.
You're talking about this order from Judge Evans?
No, well, that order and that case, they're one of the battery on the order is the same battery that was on the.
That's the ad charge.
On your capias, did they write all of the information on the front where warrants was not able to confirm?
Judge, you
That-
have,
Yes, that whole thing right there.
if what we're being
We should
told,
have been booked on the court order with the battery to resist.
But the order was done in error, we know that.
if what we're being told is this is going back to Judge Evans,
No,
Your Honor has,
It's not appropriate.
Your Honor has the same level of jurisdiction and the authority to handle this matter, and you can issue an order vacating the order that was issued on the 17th.
All right, can we set Mr. Washington on for the PM docket today? And we'll address it at that time. All right, so everybody knows Jerry Washington will be on our PM docket today, so we can address the ad charge. All right.
Hey, Judge.
Will you hold this paper for me? Thank you. All right, so going on, next will be Robert Bruno.
He's approaching, Judge.
Thank you. Good morning, Mr. Bruno.
Good morning, Judge.
Mr. Bruno, you're before the court this morning on 9 charges. Counts 1 and 2 are each a separate charge for burglary of an count 1 is for burglary of an unoccupied structure unarmed. Count 2, burglary of an unoccupied conveyance unarmed. Count 3, trespassing on an unoccupied structure or conveyance. Count 4, burglary on an unoccupied structure unarmed. 5, burglary, unoccupied conveyance unarmed. 6, first-degree petty theft. 7, criminal mischief over $1,000. 8, criminal mischief between $200 and $1,000. Count 9 is for resisting and obstructing with violence. I find probable cause for these charges, and pretrial is standing up, so I will hear from her first. Yes.
Zero 7446 CF10A for writing a threat to kill. He was custody of his pretrial as revoked. He was placed on pretrial October 3rd of 2019.
What case number is that?
190074460.
It's the second case. 182691 CF10A.
A different case.
182691 CF10A, from what I can tell.
There's a second case that's on pretrial.
Yes. 2691 CF10A. Showing October 3rd of last year, Judge Colra placed him on.
What are the charges in the 2018 case?
On that, the 2019 case, that case is possession of substituted cathinones and misdemeanor possession of cannabis.
All right, so you'll change, correct the charges. That's fine.
And Judge, I'm showing Mr. Bruno has private counsel on those two cases that are being discussed.
Okay.
However, there is a motion to withdraw filed by private counsel, which is to be heard by Judge Colra on the 24th of February.
All right. At this time, I'm going to grant pretrial's request to revoke Mr. Bruno's pretrial services and the other two case numbers. Based on the circumstances, I'll hear the parties' recommendations on both cases, and then I'll make a decision.
Your Honor, I'd ask that he be held no bond on both of the cases on pretrial. Considering the fact that he was already on a GPS monitor, that's basically how he was linked to these burglaries. There's no reason to believe that there are any release conditions this court can set that will ensure that he does not continue to commit new law offenses while out of custody.
Judge, he's right now working. He works in construction. The only person that can help post his monetary bond is a girlfriend. She works at a country club as a hostess, so their financial resources are limited. They live locally in Pompano Beach. I believe their monthly rent is approximately $800 per month. On the cases that are here before you, they're third-degree felonies. I'm going to be asking the court to consider setting a $1,000 bond on each count. Judge, and on the case that he's currently out on, I'm going to be asking for a $2,000 bond on that case, Judge.
There's two cases that are on pretrial.
Both of them are drug offenses, Judge?
One of them is writing a threat to kill. The other one is a drug offense.
Right. A $1,000 bond on each count, Judge. Told. And a photo order as well.
I'll sign the photo order. All right, first, before I go to the state's recommendations on the current case.
Your Honor, I'd be requesting.
Hold on.
I'm sorry.
On the case that was on pretrial, the two cases that were on pretrial, excuse me, based on the fact that Mr. Bruno was out on a GPS monitor and allegedly committed these new offenses while wearing the GPS monitor, which is how he was tied into these two cases, I am going to order that he be held no bond on the other two cases that were on pretrial. And now, I've heard Mr. Romero's recommendations for the current case, so I'll hear the state's recommendations for the current case.
Your Honor, based on the totality of the circumstances, I would be requesting $3,500 bond each on all of the burglary counts. No victim contact, no return.
There's also a resisting charge.
Oh, I'm sorry. I'd ask for a $500 bond on that count.
All right, in light of the no bond holds that I've placed on the other two cases, I'm going to set the bonds on counts 1, 2, 4, and 5 at $3,500 each. The bond on count 9 will be set at $500. There
Judge,
will-
I have emailed Mr. Coffey and let him know that Mr. Bruno is in custody.
Thank you. There will also be orders of no return and no victim contact. That applies to both locations that are at issue with regard to the new charges. Mr. Bruno, that means that you're not to return to either of those locations or to have contact with either of the alleged victims. Do you understand? Thank you.
Judge, I don't know if I requested a photo order on his behalf already.
Yes, I said I would sign that. Thank you.
Oh, okay, and the second request is a SAP order.
Yes, I will sign the SAP order as well. Thank you. Next will be Illidu Sharit.
Mr. Sharif, come on up, please.
Judge, I'm not sure if there's a copy attached to the picture,
Let me see.
if it's not a print.
Your Honor,
This one? Yeah, I got it. Yes, Mr. Linder?
may I approach?
Yes, come on up. Thank you.
Your Honor, if I could just advise you what I provided.
Go ahead.
And I've already shown Mr. Miller copies. The first packet is a supplemental report for this case, which it's pretty much contains most of the same facts as the probable cause affidavit. One salient fact that I think is very important is it mentions that Mr. Sharit's ex, who actually owns the home, was also present, witnessed him because he assisted in pulling him off of the victim in the case. I've also attached several pictures, Your Honor, showing the damage done to the door, a picture of the hammer that was used. You can see some a picture inside the residence, and a picture of, you can see the door handle broken off of the door. Additionally, Your Honor, because, and I know Your Honor is going to advise Mr., well, I'll wait till, the second two packets, Your Honor, I would ask that the court hold off on reviewing those at this time.
All right.
Judge, I am going to reserve all argument for another day.
Okay.
Judge, when was the date of offense on this allegation?
October of 2019 in Tamarack. All right, Mr. Sharit, for the record, you're before the court this morning on one charge of burglary with assault or battery. I find probable cause for this charge. Mr. Linder?
Thank you, Judge. Your Honor, the state would be seeking a finding of proof evident or presumption great for first appearance purposes and that Mr. Sharit be held no bond. As I mentioned, I provided the court, in addition to the original probable cause affidavit, a supplemental report which provides an additional witness that observed Mr. Sharit not only in her residence without permission, but attacking the victim in this case. I've also provided the court with photographs documenting the damage that was done to the front door that allowed Mr. Sharit to obtain entry to the home, the hammer that is referenced to that was used to damage the home as well. Additionally, Your Honor, I would ask the court, should the court make a finding of proof evident or presumption great that you not exercise discretion in setting the bond, I provided the court with two separate probable cause affidavits. One is from a domestic violence battery arrest against the same, well, not the same victim, the owner of the home, who's his ex. And in that case, it's alleged she locked herself in the bathroom in her home to try to get away from him, and he used a knife or some object to obtain entry. He also has a pending armed burglary, where he used a knife to force entry at this same woman's home. Matter of fact, in that incident, in that report, it makes reference to this October 2nd incident. And my concern is, it's obvious, Your Honor, there is a pattern of Mr. Sharit not only attacking, committing violence against this woman, but taking any means necessary to force entry into her home or rooms in her home. He will not be stopped from getting to her.
Mr. Miller, nothing to add?
Judge, as I said, I'm going to reserve.
All right. Based on all of the information that's been provided to the court this morning, at this time, I'm going to make a preliminary finding of proof evident presumption great in order that Mr. Sharit be held no bond on this charge. That is without prejudice for him to have the appropriate Arthur hearing before his division judge to further address that matter.
And, Your Honor, in an abundance of caution, I just request no contact.
There will also be an order of no victim contact, Mr. Sharit, so that you understand that order. No victim contact means you are not to have any contact with this person. That means no being in the same place at the same time. That also means no phone calls, no text messages, no third-party contact, no social media contact. Do you understand that?
This is my place of residence. I was living
Mr.
on
Sharit,
Judge-
do you understand the no contact order?
Yes, ma'am. Yes, Your Honor. And
Thank
Judge, Mr. Sharit is asking me to ask the court, and I did advise him that he applied for public defender. This is useful information to him, but my understanding is Mr. Sharit was residing there.
Does the victim reside there?
I believe that's what he's going to, by him residing there, that he didn't need permission to enter because it was his residence, he was paying rent.
There's no
So
indication of that in the probable cause affidavit. If it's an issue, then he can bring it up with his public defender and his division judge at a later date.
Judge, Mr. Sharit wishes to address the court. I've advised him not to talk about the facts of the case, but he wishes to address the court. Your Honor.
Mr. Sharit, this is a mistake, okay? You can
I'm not-
argue whatever you need to argue. You can tell your public defender anything you need to tell him, but anything you say right now is going to be recorded, and I promise you the state is paying attention, okay? And anything you say that places you at the scene or identifies you as person being involved in whatever happened is going to be used against you when you go to trial in this case. So if you can possibly hold this conversation, you probably should do that.
Okay, Your Honor, I have a full-time job. I have a child I have to take care of. And during the time of these incidents, it's just a bad breakup. And all I ask is if the court could see if I could get a $5,000 or $10,000 bond with a monitor. I just want to continue to work to take care of my child. I show up to court on January 11th. This warrant been out since December 12th. I even been to court after the warrant was issued. I'm not trying to run. I'm not trying to cause any problems to anybody. I just want to be able to be out there to work and take care of my child. I pay whatever bond that you could impose on this, up to $10,000. I could afford up to $10,000, and I'll get on a monitor.
Mr. Sharit,
Please.
I appreciate what you have said to me, but based on the information that I've been provided, I'm going to stand by the ruling at this time. I'm sure based on this, your attorneys will be taking the appropriate action so that you can discuss it with your division judge, which will probably be within the next week, I would imagine. All right, good luck to you. Next will be Johnny Santos.
Mr. Santos, come on up.
Good morning, Mr. Santos.
Good morning, Your Honor.
Mr. Santos, you're before the court this morning on 5 charges. Count 1, DUI, alcohol or drugs, first offense. Count 2, DUI with damage to property or person of another. Count 3, DUI with blood alcohol content greater than 0.15. Count 4, failure to stop or remain at an accident involving non-serious injury. Count 5 is possession of open container in a motor vehicle while driving. That count is not for magistrate. I find probable cause, and I'll hear from the parties at this time.
Your Honor, I know. It's gonna be, would be requesting, I don't see a history, would be requesting a $1,500 bond on count 4.
Mr. Romero?
Judge, considering he has no history, Judge, I was going to be requesting a $1,000 bond on count 4.
All right, I'll set the bond at 1,000 on count 4. Okay, good luck, Mr. Santos. Lincoln Grant,
Bonded.
thank you. James Oliphant,
He's approaching, Judge. Come on up, sir.
good morning, Mr. Oliphant.
Good morning.
You're before the court this morning on 2 charges. Count 1, possession of cocaine. Count 2 is a felony probation violation with a no bond hold. I find probable cause. I do see you're set to go before your division judge tomorrow morning on the VOP, so in light of that, do the parties wish to be heard on count 1?
No, Judge.
All right, that bond will remain in place. Jamarcus Battle,
And Judge, we have an argument as to counts 2 and 3.
okay.
Who did you call, Judge? I'm sorry.
It's Jamarcus Battle. He may have, well, no, he has a VOP hearing tomorrow.
Judge, he's not here in Maine. He wasn't brought.
Okay,
Your Honor, he can be ROR on counts 2 and 3. There's no basis for a 94806 violation.
okay. Mr. Miller, I imagine that's what you were going to say as well?
Mr. Linder read my mind.
Okay. All right, well, I'm not sure where Mr. Battle is, but I will ROR him on the 2 VOPs. And he's got a purge amount on his civil writ of arrest.
And a court date in front of Judge Bailey tomorrow.
That's on the VOP. Yeah, that's on the VOP.
Right.
Okay.
I mean, yeah, that's why. Hector, do you know, is there any way the deputies can get word to him? Do we know where he's being housed?
Let me ask.
In case he posts the bond in the civil writ,
He's got the hearing.
someone
tomorrow.
should get word to him that he should be contacting his probation officer upon his release.
They're looking him up right now, Judge, to see where he's at.
Okay. He's supposed to be at Maine? All right, well, they're looking him up. I'll go to the next case. We'll come back to him. All right, next is going to be Jude Hilaire.
Medical reset, Judge.
All right. Sean Eggert.
He's approaching, Judge.
Thank you. Good morning, Mr. Eggert.
Good morning.
Mr. Eggert, you're before the court this morning on 4 charges. Count 1, possession of heroin. Count 2 is an out-of-county felony hold from Palm Beach County. Counts 3 and 4 are misdemeanor capiases. Those relate to charges for trespassing and resisting or obstructing without violence. I find probable cause. I do see the out-of-county felony hold has a no bond hold on it. That's the Palm Beach County hold. So in light of that, do the parties wish to be heard on the remaining counts?
No, Judge.
Judge, and speaking of Mr. Eggert, he wishes to see if the state has a plea offer just for the counts 3 and 4, the misdemeanor offenses.
One moment.
And Judge, just to give the court information, he was housed in 2C, so he's being brought.
Okay, thank you very much. I appreciate that.
On the trespass, it's an adjudication, court cost, time served, no return to 4400 Northeast 26th Avenue in Lighthouse Point. On the resisting without violence, it's adjudication, court cost, time served.
Adjudication time served with a no return on the trespass.
He wishes to accept the state's offer, Judge.
All right. Mr. Eggert, will you please raise your right hand? Do you swear or affirm to tell the truth? Can you just?
Yes.
Thank you. All right, now you can put your hand down. Mr. Eggert, do you understand everything we've discussed here today?
I'm sorry, Judge.
I have one question, ma'am.
Okay, what's your question?
My question is, I was picked up here for the possession of heroin.
Yes.
And then I also do have an out-of-state felony. So how is this gonna work? I have to sit here and take care of this possession charge before?
Correct.
Okay,
All right.
okay.
Okay.
Yeah,
All right.
I see court for that possession?
You'll go to court on the possession charge, yeah. I don't have a
How
date for you
soon?
on that. I don't have a date for you on that right now.
Okay.
All right. Okay. All right. So, Mr. Eggert, is anyone forcing you to resolve the other 2 cases today?
No,
Are you under the influence of drugs or alcohol?
no,
Do you need any more time to speak with your attorney?
no,
Do you understand that you have the right to trial, but you're waiving that right by taking a plea today?
yes,
Have you ever been treated for mental or emotional illness?
no,
Do you understand if you are not a U.S. citizen, taking a plea today will subject you to deportation or other immigration changes?
yes.
And Mr. Eggert, what plea do you wish to enter, guilty or no contest?
Contest.
All right.
No contest.
All right, I accept your plea and find that it's freely and voluntarily given. So your sentence on just the trespassing and resisting charges will each be an adjudication time served, and there will be a no return order on the trespass charge that was discussed. And you understand that?
Yes.
All right, good luck to you, Mr. Eggert. All right, next will be Matthew Watkins.
He's here at main, Judge.
Thank you. Good morning, Mr. Watkins. Mr. Watkins, you're before the court this morning on 2 charges. Count 1, driving while license suspended, third or subsequent offense. Count 2, possession or use of drug paraphernalia. I find probable cause, and I'll hear from the parties.
Judge, we're going to be requesting pretrial release. We'll see if the state has an objection.
Okay.
It's fine.
Mr. Watkins, I'm gonna ROR you on count 1 and release you to pretrial supervision.
Thank you so much, ma'am.
You're very welcome. Mr. Romero is
Thank
gonna
you.
give you some information there. Though you're going to be released today, you must report to pretrial within 24 hours. If you fail to report to them as I've instructed you, a warrant will be issued for your arrest. Do you understand?
Yeah, well, where do you have to go to?
Just follow the map, see it's the main jail. It's across the street.
Right across the street?
On Southeast Sixth Street.
All right,
Third
so,
Avenue.
when do you think I'll be released? Within a couple hours?
It'll be by the end of the day today. Usually it takes some
Oh.
hours.
All right, thank you.
All right, you're
By the time you get
welcome.
released today, it'll be closer. You report there tomorrow morning.
All right, so either way, I have to report there today or tomorrow morning?
Correct.
Okay.
All right, good
Thank
luck,
you, guys.
Mr. Watkins. Quentin
And
Jackson.
Mr. Battle has been brought whenever the court's ready.
Okay,
He's,
I'll do Quentin Jackson and then we'll handle Mr.
Medical
Battles.
resets.
Mr. Jackson, medical?
All right, so let's see Mr. Battles.
He's approaching, Judge.
Okay.
No, we don't have to do anything. He's getting ROR to the VOPs. He just needs to contact his
All right, good morning, Mr. Battle.
probation.
Good morning.
Mr. Battle, I had them bring you down because I wanted to advise you of a couple of things, all right? You were supposed to be here this morning on a civil writ of arrest, which has a $319 purge amount associated with it, all right? That's not for me to address. And there were 2 felony probation violations. But what the attorneys are telling me is that because this is a civil writ of arrest, there's nothing to actually violate your probation. So I am going to ROR you on those 2 counts. You still have the $319 purge amount, but the important thing I want you to know is that you have a hearing in front of your division judge on the the probation violation issue tomorrow morning. So even if you pay the purge amount on the civil writ, you still should go to your division judge tomorrow morning so that you can address the probation violation issue and clear that up. You understand?
Yes, ma'am.
All right. So that's going to be tomorrow morning at 8:30. All right, so that brings us to the end of our morning docket, so I'll see everyone back here this afternoon. Thank you.
Thank you, Judge.